session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is advisory opinion to the governor regarding the implementation of Amendment 4. Counsel?
Good morning. May it please the court. For time allocation, I'm Joe Jaco on behalf of the governor, and I'll be speaking up to 10 minutes. Mo Jazeel on behalf of the Secretary of State, speaking up to 10 minutes. Jeremiah Hawks on behalf of the Florida Senate, up to 5 minutes. And Jonathan Williams on behalf of the Florida House, up to 5 minutes. And then I'll return for rebuttal, up to 5 minutes as needed. Elections are coming. Indeed, we had some yesterday. And the governor has responsibility to protect the integrity of the electoral process. Governor DeSantis wants to ensure felons are constitutionally entitled to regain their voting rights and are able to do so once they have paid their debts to society. The governor exercised his constitutional powers to seek an opinion not because of ambiguity in the text of Amendment 4, but for authority and an interpretation from this court. The other parties here today have sought interpretations of Amendment 4 from the Secretary of State. They have brought federal litigation implicating interpretations of the constitutional provision, and they have even countered the explanation of Amendment 4's sponsor before this court on the proposed amendment. In respect for our branches of government and the judiciary's role, the governor seeks this court to render a final interpretation of whether Amendment 4 requires legal financial obligations within a sentence to be completed before a felon regains voting rights. This court's analysis of Amendment 4 should begin and end with its plain language. As stated to this court on the proposed amendment, all terms of a sentence means all matters.
Can I ask a quick question on the jurisdictional aspect? Why not rely on the governor's clemency powers as part of the clemency board, as part of the reason for seeking an opinion from this court? You rely on the shall faithfully execute clause. You rely on him being in charge of subordinate officers who have responsibility to take care of elections, some statutory authority about what the Secretary of State must do. But conspicuously absent to me is any reliance on clemency powers, which the governor clearly has an interest in. Why not rely on that?
Sure. I mean, the clemency powers are certainly exclusive to the governor and the cabinet. But what Amendment 4 did is create a new avenue outside of that clemency process for these felons. And it is only on that provision of which the governor is seeking this question.
Must someone, let's say someone qualifies, absent the question that's before us, don't they still have to go through the clemency process to say, hey, I qualify under this and I need a restoration of my rights? In other words, there has to be some official piece of paper that's issued to someone at some point, I would imagine, to say my rights are restored, right?
Well, through Amendment 4, I mean, certainly those that wish to exercise their Amendment 4 rights have the ability to register, and it's incumbent on the Secretary of State to evaluate that and to make a decision to pull them off the registry if they don't qualify, whether they've committed a murder, sexual offense, or haven't completed the terms of their sentence.
But your position is that's outside the clemency process?
That is an exception that's been created outside the clemency process.
Now, my second question regarding that is that the exclusive means by someone for a felon, that someone who is a felon and has now come off a sentence, whatever that sentence be, is that the exclusive means to have rights restored?
We don't see it that way. No,
Isn't that what the court said?
Excuse me?
Isn't that what we said? Didn't we say in the 2017 opinion, allowing Amendment 4 or saying that Amendment 4 was appropriate to be put on the ballot and met the statutory and constitutional requirements for being on the ballot, that it was the exclusive means for restoration of rights for felons?
Well, there are going to be some felons that don't get rights under Amendment 4. So for those felons, the clemency process is still open.
But I think I think what Justice Luck is, there's a line in our opinion approving this replacement on the ballot where it suggests that if someone hasn't committed murder or one of the sex crimes, that they essentially no longer could go through the clemency process. And I think what Justice Luck is trying to clarify from you is that regardless of whether this changes the disqualification for this, other broader category of felons, there's nothing that would prevent them from applying for clemency. I mean, subject to the rules or whatever, there's nothing that would prevent the governor and the members of the cabinet from allowing people to apply for clemency prior to the disqualification ending under the new provision.
Yes, and certainly that's clear for those that have committed murder or sexual offenses.
But it's also true of these other people. I mean, obviously the governor and the cabinet could exercise their discretion however they like, but there's nothing about the text of Amendment 4 that says that these people can no longer also seek to go through the regular clemency process if they want.
That's available.
Okay.
I mean, there's nothing in the amendment, in the text of the amendment, that's self-executing. I mean, you still have to do something in order to have your right restored.
Right. The right exists in Amendment 4, but certainly that right has to be implemented in the sense that once someone registers to vote, the secretary then has to evaluate that. So, right, there is.
But there has to be qualifications that have to be met, that either they've, completed parole, probation, and obviously completion of all terms of sentence, which is why we're here. But there has to be something more. It's not an automatic. It's not like when your birthday happens, you automatically turn a year older.
No, to evaluate completion of a sentence is definitely going to be a matter of execution. The common understanding of sentence includes terms in a judge's oral pronouncement and those in law memorialized in a sentencing document. Now, this is no tautology. All terms of sentence in Amendment 4's constitutional provision refers to everything that is a term and a condition in the judge's sentencing order. When sentencing includes legal financial obligations, or LFOs, fines, restitution, fees, and costs, then completion of all terms of sentence requires the satisfaction of those LFOs. The other parties have claimed that all terms of the sentence, including parole or probation, really means only imprisonment, parole, or probation. Yet the provision at issue is not all terms of incarceration. It's not all terms of punishment. It's not even all terms that are only punitive. All terms means all of the conditions that are in the sentencing order. Amendment 4 restores voting rights only upon completion of those terms of a sentence. So fulfilling the LFOs is a condition precedent to voting. And as those LFOs are terms of the sentence that may even extend beyond the time of parole or probation, Amendment 4 does not provide voting rights unless and until they are complete. Now, the other parties have argued that LFOs are something different, that they're non-punitive. Yet this is not based on Amendment 4's text. This is select theories of criminal justice.
Isn't the textual argument from the opposing side, or at least maybe the best textual argument from the opposing side, that when you have specific examples after a general term, the general term is to be read consistent with those specific examples?
Well, that's
generally the rule, right?
No, well, that is the argument that's being made at the other side. But when we have in the phrase including parole or probation, including has always been interpreted, including by this court, as a non-exhaustive list, right? Not as a limit.
There's no doubt about that. Yeah. But in that non-exhaustive, I agree completely. But in that non-exhaustive list, in other words, in evaluating what other things are there, isn't that which is listed define the scope of what's both inclusive and exclusive of what would be in that list.
No, it doesn't define the scope in terms of a limitation on what all terms of a sentence is. It is an expansion. It's showing what should be considered.
Right. Agreed. So how is costs and fines, or costs and fees in particular, like parole and probation?
Costs and fees are normally in a judge's sentence. What parole and probation are something that is not normally or always.
Doesn't the judgment and sentence typically include at least a term of probation?
It does, but certainly not parole.
That's true.
And certainly probation can have aspects that are determined later, even the discretion of a probation officer in a limited way.
And you don't get the conditions of probation until probation happens, where then you have to sign the form that discusses what your conditions of probation are until probation actually starts.
Yeah. So those are elements that happen after, at times, a sentencing order, and thus are brought into the definition of what all terms of sentence are. But those cost, fees, restitution, fines do happen at the time that sentence is memorialized.
But that doesn't answer the question of whether it is a sentence or not. I understand that it happens at the same time. But the question that we're asked to answer is a cost and a fee a sentence? Because it's not probation, you would agree.
It's not probation.
And it's not parole.
But those terms that are in the including phrase don't limit what is all terms of the sentence. I mean,
But it has to be like those things. In other words, it can't be apples and oranges. Those are not like probation and parole. It has to be, the list has to be something, the things that are outside of it have to be like that which is within it, right?
Well, they're like in the sense that they're parts of the sentence.
Sure.
That including parole and probation are treated as parts of the sentence. But they're not like it in the sense that they have to have some punitive nature, or that there's some constraint that comes from the included that should be imported into the broad and expansive phrase.
Let me ask you this. How then do we define the basket? Knowing that it includes two things, how do we define that basket?
And that basket is defined by what is in a judge's sentencing order.
What about restitution, though? For example, restitution could be part of the condition of probation as opposed to the judgment and sentence.
Right, so restitution...
And now, it could be part of the judgment and sentence as well, but let's just deal with restitution as probation.
Sure, so when we look at the sentencing order, we look at both the discretionary items that are pronounced by the judge as well as those that are in law that are then brought together. And now, certainly restitution is encompassed in that, whether it's provisions in the law, whether it's brought into that final sentencing order once there's a determination made of what the restitution amounts are. And certainly we believe that restitution as a condition for ending parole continues throughout the time of the probation, and even if put into a civil lien, that enforcement mechanism is only to enforce what was already in the sentence.
Is that issue something that we have to decide for purposes of the governor's request, whether or not something that's been converted to a civil lien, the restitution, still constitutes part of the obligations subject to the requirements?
Well, what the governor's request in this court to decide is that all terms of a sentence includes everything that is in a judge's sentencing order.
Right,
and
so let's assume that restitution is part of that order and would be part of the things that should be considered. But do we really have to consider, for purposes of answering this request, whether or not something that's been converted to a civil lien should also be included or not?
Well, I think that if this court determines that restitution is in the sentencing order, then that is exactly what Amendment 4 captures. Whether there's an enforcement mechanism, a more effective enforcement mechanism that happens through a civil process, shouldn't undo what was in the judge's sentencing order.
Well, it seems to me the point of my question is that seems like a whole separate issue. And, you know, maybe the terms of the sentencing order may or may not be different. I don't know of what the language in the sentencing order says and what the orders say on the conversion upon to a civil lien. Maybe they vary according to from different parts of the state to to each other. So maybe that needs to be fleshed out in some kind of declaratory action in some way as opposed to just an advisory opinion from the court. What are your thoughts on that?
Well, we'll take whatever a judge does. So if he or she puts in the sentencing order these terms and conditions, then we think that that is what is captured.
But how is that? How can it be that the sentencing order, which is going to change from defendant to defendant, and I agree with Justice Polson, to circuit, be what was? How can there be a fixed definition for sentence of what the voters understood it to mean? What was understood at the time that it was enacted to be what was in the four corners of a document that's going to change from defendant to defendant to circuit to circuit?
Well, I think certainly the voters understand that these are individualized decisions made by courts every day, by judges on defendants every day, and that whatever the judge hands down, those debts to society have to be repaid before one regains his voting rights. So I think the phrase, the expansive phrase, all terms of sentence, is intended to capture everything that a judge puts in a sentencing order, whether those are discretionary items or whether those are items required by law.
Even if it's illegal?
Well, certainly, if it's illegal, there's a process to challenge those illegal sentences, and once that has been done and upheld, then the result of that would provide a new sentence.
Chief,
I'm sorry.
You've now used all your time,
Chief,
including your.
Can I ask one question?
Sure.
I just want to make, because this goes to the question from Justice Polson about the scope of your question. It seems like what he's asking about goes to the issue of completion. And does your question, are you asking us to also address what completion of the terms of the sentence mean? Because it seems like the conversion to the civil lien kind of relates to that aspect of it.
And we are not. Yeah, the question the governor posed to the court is whether legal financial obligations are included in the phrase all terms of sentence.
Okay, so what completion means is not part of your question.
Correct.
Okay.
Yeah.
All right,
Thank you.
counsel, since we helped you a lot to consume all your rebuttal time, plus a little more, I will give you 2 minutes for rebuttal, and I'm going to give the other side an additional 2 minutes as well.
Thank you.
May it please the court, Mohammed Jazeel here on behalf of Secretary of State Laurel M. Lee. The governor seeks an advisory opinion to provide some measure of finality and certainty as we head into a presidential election here. The Secretary of State agrees, but also asks for consistency between the meaning of the phrase completion of all terms of sentence as considered and approved by this court in 2017 and the meaning of that same phrase now. In 2017, this court, the state, and the electorate were all told that the phrase completion of all terms of sentence includes fines, fees, costs, restitution.
Well, we were told that here, but voters were also told that in different editorials and opinion pieces throughout the state, correct?
Yes, Your Honor, they were. And the words didn't change. The meaning attached to them by some did. And constitutional text, especially constitutional text added through the citizen initiative process, where this court has an obligation to review to make sure that the ballot summaries are clear and unambiguous, the meaning should be fixed. The meaning should not change. The words shouldn't change. The meaning shouldn't change. So the Secretary, in a nutshell, asked that the phrase completion of all terms of sentence includes financial obligations now, just as it did in 2017.
I'm sorry to interrupt you. Can I ask you a question, and just kind of picking up on what Justice Luck
Yes, Your Honor.
was asking? What work is the including parole and probation language? What work is that doing, and what was added to the Constitution?
Your Honor, I read that word including, number one, as a word that provides a list of examples.
Okay,
and I think we can all agree that it
right. That's a given. But what is it completely superfluous? I mean, is all terms of sentence, does that do nothing? Does that do nothing to help us understand what sentence means?
No, Your Honor, I don't think that it's completely superfluous. So we have two phrases, all terms of sentence, there's an including in the middle, and then we have parole and probation. Parole and probation, as my friend for the governor pointed out, may or may not be included in the sentencing document. Parole isn't, probation is.
But we agree that parole or probation are after someone completes an actual imprisonment.
Yes, Your Honor. And one way to read including parole and probation is to read it as an attempt to capture everything that someone might have to do to satisfy their debt to society, as my friend Mr. Jaco said. If you violate the social contract, certain punishments are meted out. Those punishments are usually included within the four corners of the sentencing document, as this court has been previously told, and they include parole and probation. So this, one way to read the phrase completion of all terms of sentence, including parole and probation, is that they're trying to capture the entire universe of punishment that's been accorded to the defendant.
But you're not arguing that now, because obviously you want the punishment to include the fines, restitution costs. I mean, is it clarifying an ambiguity in the term sentence that would have been there without the including parole and probation?
That's one way to read it. I don't think we need to get there, though, because, again, Your Honor led the question with, should we read the phrase in such a way where all terms of sentence is rendered superfluous? And I don't think...
No, I'm asking if including parole and probation is superfluous.
It is not superfluous. It is not superfluous. I believe including parole and probation captures the entire universe of punishment that is given out to the defendant. And
well, doesn't it suggest...
You're not saying that those two phrases capture the entire
no,
universe.
Your Honor. Those two phrases...
That's part of making sure that the whole universe is covered.
Precisely, Your Honor. Your Honor said it better than I did.
They're not... How could they be superfluous? Don't they imply that it doesn't just mean that someone satisfies and gets their rights restored upon leaving jail? I mean, it means that there's something more, including that language, parole or probation.
Yes.
Let me focus you on the text and different ways that this could be understood. I mean, we recognize that term could mean a length of time or period of time, correct?
That is one definition, yes, Your Honor.
Okay, the parole and probation, the fact that that's included, focuses on the length of time associated with the restriction on the liberty interest of the defendant. I mean, if we talked about a term of incarceration, that would be a length of time associated with the most severe liberty interest infringement, which is incarceration, and then parole and probation is a further length of time where the liberty interest is impaired, correct?
Yes, Your Honor.
Okay. So, but it's the language is a felony conviction. And so it wouldn't make any sense to use term, to me, in terms of a length of time, because there's only ever one length of time that someone has their liberty interest impaired associated with a single felony conviction. Doesn't that eliminate that use of the word, the length of time, use of the word term? The fact that it does say a felony conviction. So we're talking about terms of sentence associated with a felony conviction, which means it has to be talking about, I would think, the alternative, which is provisions of the sentence, conditions of the sentence.
Precisely, Your Honor. And we note the point in our briefs that we have in front of us a constitutional provision that talks about a conviction, and then it talks about terms of sentence for that conviction. It is analogous to a term of lease, which is the temporal duration, and the terms of lease, which are all the conditions that are included in the lease, singular, conviction singular, term plural, term singular. So we agree with...
And then once you get there, irrespective of anything else, if terms is talking about provisions or conditions, I don't know, I mean, all terms couldn't mean anything, I don't think, other than all terms, which would include everything the judge pronounces and everything that's part of the sentence, right? I mean...
Yes, Your Honor.
Okay.
And it's important to note that that is a position that was taken early on in 2017, and based on the representations made by an officer of this court to this court about what that phrase meant, this court concluded that the phrase was clear and unambiguous. Clear and unambiguous. So if we now find an ambiguity after the fact after it's been included into the Constitution, this creates a bit of a conundrum for us, because we had in front of this court a process, a citizen initiative process, which the Department of State takes very seriously, where this court had before it the language, and this very language, and the court concluded that the language was clear and unambiguous because this is not a legal phrase, this is not a legal phrase of significance, this is a phrase that people can understand. And people understood it, per the proponent's counsel, to mean everything that's included in the sentencing document.
But just to, I'm sorry to interrupt you, but just to be clear on that, the summary has to be clear and unambiguous in relation to what's in the proposed amendment. And so the summary doesn't need to be more clear than the amendment itself. So if the amendment itself has ambiguity, and I'm not saying that this is ambiguous, then if you're merely parroting the words in the summary that are in the amendment, then that's, you know, that's all that you can ask people to do, right? I mean, there's nothing that says that if a proposal is, there's nothing that says that ambiguous proposals are not allowed to be put on the ballot, right?
Well, Your Honor, ambiguous proposals would not be allowed to be placed on the ballot.
So that's a new test. So when we look at an initiative, we have to independently evaluate the proposal to see if the proposal itself is. I'm not talking about the words of the summary. I'm talking about the text that is proposed to be added to the Constitution. Only things that are clear and unambiguous can be added to the Constitution.
Well, no, Your Honor. I think we have to look at what the summary is a summary of. If it's a summary of something that is clear and unambiguous, and the summary itself can track the legislative language, and there's no problem. But if the summary is trying to capture what a ballot initiative means for the voter, because remember, the voter doesn't see the actual initiative language itself. All they see is a summary on the Election Day ballot. And if we are saying that the summary can be as ambiguous as if the summary simply tracks the language of an otherwise ambiguous constitutional initiative, that's not a summary at all. That's not a summary that's providing folks an opportunity to know what exactly it is they're voting on. And this is not something new. This court's precedents, Smith versus American Airlines, the advisory opinion regarding the property rights amendments, and the advisory opinion regarding treating people differently all talk about this concept where the summary actually has to capture.
Okay. Well, that's a pretty, I mean, that's a bigger issue than what we have to deal with today.
Yes, Your Honor. If there are no other questions, perhaps I can reserve the balance of my time for my friend's rebuttal.
He's got all he's going to get.
Thank you, Your Honor.
May it please the Court, Jeremiah Hawks on behalf of the Florida Senate and President Bill Galvano. I want to start off with Justice Luck's earlier question about clemency, because I think that is an important issue to look at. You have said in the past that the power and rights of pardon and restoration of civil rights vest in the executive. And then you subsequently explained, and that was in the advisory opinion regarding civil rights. And that case is interesting because what happened there is the legislature passed a statute that it provided for automatic restoration of civil rights for felons. And the court said the governor has the power of clemency, which left the necessary implication that the statute was unconstitutional. And the court, further expounding on that in Sullivan v. Askew, said, this prohibition against legislative encroachment upon the executive's clemency power is equally applicable to the judiciary. So one of the reasons why the question that you're answering here today is so important is because Amendment 4 means what it means. The legislature can't expand on that. The court can't expand on that. What rights it gives back are the rights that it gives back, nothing more.
But counsel, if you're asking us to give deference to how the legislature has defined the term, doesn't that presuppose that there's some ambiguity about how the term is defined?
Well, if the court were to go there, and as we pointed out in the brief, we don't think there's an ambiguity. We think if you read the whole thing in context, that the legal financial obligations are included. As Justice Lawson walked through with, it comes down a lot to terms versus term and period of time and all that. And as Justice Lawson pointed out, you know, you do have to come to the conclusion that terms is
so if we're to look at the language and to conclude exactly what it means, then there'd be no reason for us at all ever, despite the fact that we're not asked to look at it, to ever look at whatever the statute the legislature passed, right?
If you find no ambiguity, then you would not need to look at what the legislature passed. All our brief says is that if you do find an ambiguity, then a contemporaneous interpretation by the legislature should be given a great deal of weight and deference by the court, because the legislature is the representative body of the people, and so interpreting what the people's natural law is, there should be deference to the legislature. Now,
I'm sorry to interrupt you. So if we do think that there's an ambiguity, given that you're representing the legislature, why would you want us to even answer the question? Because once we answer the question, then we're kind of necessarily, or at least depending on how we word it, we're potentially constraining the ability of the legislature later on to change its mind and interpret the term reasonably, but within the zone of what the ambiguity would permit. So why, wearing your legislative hat, why would you want us to answer it unless we can say that it only has one permissible meaning?
Because we did an implementing statute, and we think that, again, if the court finds an ambiguity, that the court should look to the guidance that the legislature has given it and that contemporaneous interpretation, because we've already acted. And so
But I mean, the legislature could change its mind. I mean, why would you want us to lock in a particular meaning?
Because that is the meaning that the legislature has said, and that we don't think later enactments by the legislature are going to carry the same weight.
Well, let me ask you a question. It's your understanding that this statute or this amendment is not self-executing, and that's the reason or the need for the implementing statute?
Correct, Your Honor. We do not believe it is self-executing, no. The whole election system requires, the construction statutes, how people register, when people can register, how people vote, and in this statute, regardless of what interpretation is given, is going to require a lot of coordination between the Department of Corrections and the clerks of the court, who were not prior participants in the statute, to provide information. So we do think that there was a need for an implementing statute in order for this amendment to work. And we did that as promptly as we could. If there are no further questions, I'll sit down.
Mr. Chief Justice, and may it please the Court, Jonathan Williams on behalf of the Florida House of Representatives. The House agrees with the Governor that the justices should answer the question posed in the affirmative, and rather than retread the arguments that have already been made, I'd like to address two ways in which the House's brief has been misconstrued by those who disagree with the Governor's interpretation. I'd first like to start with the House's statement that the phrase terms of sentence, when read with no context at all, is susceptible to multiple meanings. The House's view is that that's a fairly unremarkable statement. The English language is full of words and terms that, standing alone without context, are ambiguous. Take, for example, the word court. That could refer to this court, that could refer to a basketball court, that could refer to the process by which one woos a potential lover. It's context that gives terms meaning. And the House's position is that when read in context, particularly in context of Florida's law on sentencing, that existed at the time that this amendment was adopted, that ambiguity disappears. As we explained in our brief, under the judicial decisions and statutes that were in place at the time of the amendment's adoption, financial terms were part of a sentence under Florida law. Thus, had the framers of the amendment intended that those terms not be satisfied, the framers should have used some term of limitation to make that intent clear.
At least with regard to costs and fees, though, there seems to be some counterindications in the statute by saying, in addition to the sentence, you are to impose X or Y, which would seem to indicate there's also case law suggesting that those things are civil in nature rather than criminal in nature. How then are we to read that those counterindications if the public meaning of what sentence meant is defined by what the law was existing at the time?
Well, so there are some statutes concerning fees that do make it fairly clear that fees would be included. For example, Section 2752(1)(b)(2) calls on the fee for a court-appointed defender to be made part of the sentence in the event that is not
Are we then in answering the question then to parse out which fees are called sentence, like the one you've just referenced, and those that seem to indicate that they're not sentence or in addition to criminal sanction?
Respectfully, Justice Locke, I would defer to the governor on the scope of the opinion that the governor is seeking. The aim of the House's brief was simply to make clear that under Florida law existing at the time that the amendment was adopted, it was clear that there were financial terms of sentence under the law, and that the mere fact that a term might be financial does not mean that it's not among the terms of sentence that must be completed.
Well, let me ask you this. I understand you don't want to answer an uncomfortable question, but if your co-counsel or cohort here has said that we should define sentence essentially by the four corners of what the sentencing document is, you've come to tell us that we should define it by what existing law was at the time. If those are contrary to each other in some way, which one are we to look at?
Well, I don't think there's a contradiction, and it's because what the House is saying by referencing prior law is saying that it is clear that financial conditions can be part of a sentence, and therefore the arguments that financial conditions are never part of terms of sentence that must be completed is an incorrect argument in the House's view. The House was not really staking out a position as to whether particular components.
Well, let me ask it this way. Is it enough for us to answer the question that it can be, that restitution, fines, fees, and costs can be, LFOs can be part of sentence, and then to litigate, have folks litigate it from there?
Again, Your Honor, and it's not because the House is uncomfortable with the question. It's in the House's view, the scope of the governor's question is really something that the governor should clarify and not that the House should clarify. I think that's a question that's appropriately directed toward the governor.
So, I'm sorry, so is your position, though, that it is possible, if we're sticking with the text, that it is possible to distinguish some fees as not being part of the sentence and others that would be?
The House doesn't take a position on that. The House's brief was aimed at making clear that under existing Florida law, there were at least some conditions that were financial in nature that were imposed as part of sentences, and that makes it clear.
But so right now, though, is your position that it's an all or nothing thing, or would someone have to really look at each particular fee or cost and make a judgment as to whether that should be deemed, quote unquote, part of the sentence or not?
And again, Justice Muniz, I don't mean to seem evasive, but the House doesn't have a position on that issue at this time, and I'm of course reluctant to create one on the fly. So while I'd like to assist you with that, I'm afraid I can't. The second...
Counsel, your time has expired.
Well, now sit down. Thank you.
When it goes red there, it starts counting up. And so that doesn't mean you're getting more time. That means you're more in overtime. But thank you.
Mr. Chief Justice, and may it please the court. Good morning, my name is Anton Marino. I will be addressing the impropriety of the governor's request and a textual analysis of Amendment 4. My colleague, Molly Danahy, will be addressing how the governor and the other state components' interpretation of Amendment 4 runs contrary to the United States Constitution. When a supermajority of Florida's voters ratified Amendment 4, they did so understanding the chief purpose of Amendment 4 was to end lifetime disenfranchisement and to automatically restore the voting rights.
Let me ask you a question about this automatic restoration, because your brief talks a lot about this automatic restoration. But where in the text of Amendment 4 is the language that says it's automatic?
I understand, Your Honor. So, generally speaking, this court, since its decision in Gray versus Bryant, has indicated that there is a presumption that citizen initiatives that become part of the Constitution are indeed self-executing. And this court, applying that and understanding that, recognized that that Amendment 4 is indeed automatic, is to provide automatic restoration. Indeed, in its 2017 decision, it unanimously held that it was to automatically restore the voting rights of
But
returning
how
citizens.
is it self-executing? How is Amendment 4 self-executing? Because it seems to me that there has to be something that the person who is now no longer disenfranchised has to do something in order to have their rights restored.
Well, what the returning citizen needs to do is complete their term of sentence. And indeed, we argue that the returning citizen does indeed complete their term of sentence upon the completion of any term of imprisonment, any term of parole, and any term of probation. And to answer your question, Your Honor, the Great Court acknowledged that there are certainly instances where the legislature can supplement even self-executing amendments through certain implementation provisions. But what the legislature may not do is nullify the entire purpose of the amendment. And the chief purpose of Amendment 4, again, was to end lifetime disenfranchisement.
Counsel, though, so I understand that you're primarily arguing to us, and that your first argument to us is purpose. But to me, the meaning has to derive from the text and has to flow from the text. And when you've talked about term, the term being in durational sense, but that's not the actual word that's used in the Constitution as Justice Lawson Act. It's actually the plural terms, right?
Correct. The word in the actual provision does indicate terms.
And it's modified, as Justice Lawson pointed out, by the term felony or conviction, felony conviction, right?
Well, I don't know if terms is modified by sentence, Your Honor.
No, it's terms of sentence.
Correct,
But
yeah.
what does that phrase, terms of sentence, modify? That it modifies the singular a felony or a felony conviction, right?
That is true, and there are instances, Your Honor, throughout the Florida statutes that indicate that a judge can impose both a term of imprisonment and a term of probation.
But what's the most natural, when you have a singular with terms, what is the most natural understanding of that language? Is it that is durational? In other words, we're talking about multiple terms? Or is it conditional, meaning terms of something, the conditions of what that is?
Well, I think, again, Your Honor, you have to look at terms within the context of the entirety of the provision.
Sure.
And the provision, as you know, notes upon completion of terms of sentence, including parole and probation. And I recognize that this court had some discussion regarding...
No, actually it says all terms.
Thank
not,
you.
Yeah.
Thank you, Your Honor. And I recognize that this court had some discussion during its colloquy with opposing counsel regarding the meaning of the word including, or what all indeed means. And certainly, looking at all, one would still have to look to either the associated word canon or to eius generis.
I'm sorry to interrupt you. Can we just go back to something very basic, though?
Yes, Your Honor.
Can you explain to us your December 2018 letter to the Secretary of State where you and when I say you, I mean the ACLU is one of the signatories, very explicitly says completion of all terms of sentence includes period of incarceration, probation, parole, and financial obligations imposed as part of an individual sentence. So this is directly on point. I'm not suggesting that the words mean what they mean because you said that they mean that, but I think that this letter reflects your understanding of what the words should mean, what the voters did. And so I'm having a hard time understanding how we get from this very clear statement in the letter to what you're arguing now.
So the December 2019 letter, as well as the March 2019 letter, do acknowledge that there may be instances where legal financial obligations as conditions of both parole and probation are contemplated within the meaning of sentence. However, it's always been our position, Your Honor, that the restoration cannot be dependent on a person's ability to pay any outstanding legal financial obligations.
You say it's always been? I haven't seen anything submitted where that position was taken before this lawsuit.
And you're saying the ACLU's position?
The ACLU's position, Your Honor, my understanding, Your Honor, is that the position of every party that was, or rather every portion that was part of the sponsorship did understand, first of all, that...
But how is that possible? Because when the ACLU in particular, when you had a voter guide about constitutional amendments specifically said, the ACLU of Florida supports Amendment 4, which would return the eligibility to vote to Floridians who have completed the terms of their sentences, including any probation, parole, fines, or restitution. This is what was told to the voters of Florida.
So again,
and in addition to that, there's other things. This is from the Miami Herald, an op-ed piece. To be eligible, the felons must complete all terms of sentence. That means would have completed house arrest, jail and prison sentences, and community service, paid restitution, court costs and fees, and fulfilled any other special conditions of parole or probation.
Right, and restitution as well as other legal financial obligations are conditions of parole and probation. And so to the extent that they are conditions of parole and probation, they are indeed part of the sentence. However, the legislature has already created a situation, and I recognize there were questions regarding this earlier, regarding what happens when an individual is unable to pay those legal financial obligations upon the completion of their parole and probation.
So why wouldn't, if I'm pronouncing a sentence today, there's nobody that's parole eligible for an offense that's been committed in a long time. So for a non-parole eligible defendant, and I say I'm sentencing you to 5 years in state prison, $5,000 of restitution, a $2,000 fine, and court costs in the amount of $973. What are the conditions of that sentence?
So for purposes of Amendment 4, Your Honor.
Just what are the conditions of that sentence? What are all conditions of that sentence?
Well, again, I think there's a distinction to be drawn between terms and conditions, Your Honor. And if we're talking about conditions, then of course...
Okay, what are all terms of that sentence?
Sure. So the terms, Your Honor, would be instances where that person was subject to either imprisonment or probation if they were also subject to probation. And again, I would
so
like...
Are you suggesting that restitution, that the trial court just ordered $5,000 of restitution to the victim, that is not a term of sentence? Well, that would be new to me under Florida law.
Well, it's certainly not intended to be penal, Your Honor, and the legislature, in passing Section 775.08 of the Florida statutes and Section 938.30 of the Florida statutes, does indicate first that restitution is intended to be remedial in nature. It's intended to provide an opportunity for the offender to make the crime victim whole in the instances where they're able to. But the reason that the legislature carved out these two provisions...
But if I could go back, because the sentence that I hypothetically pronounced did not have a possibility of parole and did not include a term of probation. It had a 5-year prison term and a number of other conditions. And if I ask you, what are all terms of the sentence, what would your answer be?
My answer, Your Honor, would be that the term is the term of imprisonment. That's the only term that's identified because it's durational. The others, of course, would be conditions to the sentencing order of the judgment.
So your view is that the word terms can only mean a length of time or period of time?
Well, our position, Your Honor, if you look at the text and look at a fair reading of the amendment, yes, terms would be durational in nature. It wouldn't be conditions.
So I want to go back to the text because we got derailed from it a little bit. What is including then, other than, because including has to mean something other than that which is listed, right?
Well, including can mean something other than that which is listed.
We've said it does mean that, haven't we?
Sure.
Okay.
Sure.
So what does it mean other than parole and probation?
So it would mean things that essentially are instances where the returning citizen or the offender's liberty is subject to the state's control. So again, instances
Isn't an obligation to pay something a restriction on liberty?
Not necessarily, Your Honor.
Really? If hanging over my head was a judgment in which to pay back something under a certain amount of time, or even not, that isn't a restriction on my ability to do things that I otherwise wouldn't want to do?
It may be a restriction to a certain degree, Your Honor. However, again...
Isn't that enough to a certain degree?
No, Your Honor, because what the language, again, contemplates is simply just...
Well, let me ask you this. How is it any different than... So in my jurisdiction, where I was a trial court judge, we would often impose what's called administrative probation. It's authorized by statute. And administrative probation really is not probation at all. You're on probation, but you don't need to report. You don't need to do anything. You don't need to pay any fees regarding it. It's just there, and then it expires on its own after it has to be less than a year's amount of time. That's a very broad, very little restriction. Isn't that less than if I'm imposing a $150,000 restitution obligation or a $50,000 fine that one must pay?
It is a restriction, Your Honor, and I think it's important to look at perhaps the purpose behind including probation and parole within the text of the amendment. And I'd like to draw this court's attention actually to the Secretary of State's supplemental appendix at pages 42, 99, 100, 121, 122, 71, 129, 101, and 109. And there was significant ballot polling done, as Your Honors are aware, and what voters, or at least those who were polled at the time, were concerned about was simply restoring rights upon the completion of any term of imprisonment, but wanted to make sure that the person had also completed any period of supervised release. But in addition to that, Your Honor, there was some concern about the ambiguity of what would happen if an individual were sentenced to probation, but were not sentenced perhaps to a term of incarceration.
Can I go back? Can I go back to regarding term? Because I thought you started to say, I thought that we have to look at what that means in relation to the entire section or article. And as I understand it, within the same article and section, there's a use of the singular term referring to a term of office, correct?
There is indeed a use of the singular term referring to a term of office.
Doesn't the juxtaposition between those two indicate the difference between the use as a durational term and the use as a term of condition?
No, Your Honor, and here's why. So there can be sequential terms of imprisonment and probation as part of one sentence. Indeed, Section 948.012(2)b of the Florida statutes permits the trial court to impose both a term of imprisonment and a term of probation.
I understand the statute authorizes split sentences. That's what you're referring to.
Yes, Your Honor.
We all understand that, but is the plain understanding of what the voter understood it to mean, the public, in enacting this, what understanding of the definition of a split sentence, or is it what the natural reading of the singular followed by the plural terms is?
So I think Your Honor raises a very important point, which is what the voter would have thought when they read the text. And as the Secretary of State's counsel notes, all the voters had available to them when they actually went to the ballot box and were in there for 5 to 10 minutes, either approving or rejecting the amendment, was the summary and the title. The title itself is entitled the Voter Restoration Amendment. The ballot summary itself indicates that its purpose, its chief purpose, is to restore voting rights upon completion of the terms of sentence.
Unlike other amendments that have been proposed and submitted to voters in the state of Florida, this ballot summary actually is identical to the text that's currently before us.
That is correct, Your Honor. And no person, or I think it would be speculative, it'd be entirely speculative to say that within the 5 to 10 minutes that a voter is in the ballot box casting their vote, approving for or rejecting the amendment, that they contemplate all of the close parsing and reading and
so are you
strange
suggesting
reading
that there's an ambiguity? Are you suggesting there's an ambiguity then in the amendment language?
If there is indeed an ambiguity in the language, Your Honor, then, and I don't want to go too much into my colleague's argument because I don't want to be too repetitive, but if there is an ambiguity, then this court should read the amendment in pari with the United States Constitution, and there are several instances where legal financial obligations, if they do become...
Well, should we do that, or should it be stricken?
No, Your Honor. So invalidating a citizen's initiative ballot is not something that would be a proper remedy before this court to consider in an advisory opinion. Indeed, I want to actually, while we're on the subject of jurisdiction, Your Honor, I do want to kind of address a few instances where the governor suggests that...
Before we go to jurisdiction, can you talk to me, since one of the things that we're talking about is what the public's understanding was of the terms of this proposed ballot summary and the actual text, because they're identical. How do we then deal with the fact that there were different op-ed pieces, there were voter guides that specifically discussed what was meant by terms, all terms of sentence, including probation, fines, restitution, parole? I mean, I have reams here of op-ed pieces and editorials from different papers all over the state of Florida that made it clear that this included restitution and fines.
So ordinarily, this court looks specifically to the title and the summary because it's the only thing that the court can identify as all voters having seen when they cast their ballots.
But we've looked beyond that, haven't we?
In instances, yes, Your Honor, to see some discussion regarding what general understandings of the citizen initiative would be. However, this court typically begins their analysis with a title and summary. I do want to spend a brief moment, because I'm running out of time, regarding jurisdiction.
And you're going to get a couple of extra minutes because the other side.
Thank you, Your Honor. So, regarding the issue of jurisdiction, the Governor's Council suggests that he wants a clear and static answer regarding what this amendment means. The advisory opinion process is not the appropriate avenue to get a clear definition. Indeed, this court has acknowledged in numerous opinions that any advisory opinion issued by the court is merely persuasive. It's not binding even on this court, and it's indicated that individuals who might be interested in an adversarial proceeding can then relitigate the entire case.
But the government, the governor has to conduct an election, and the governor's asking us for guidance on how to do that in a way that encapsulates their job to here are the voter rolls, here who is entitled to vote. How is that not entitled to an answer by us?
So, Your Honor, one point that's raised repeatedly on the other side is that words matter. And I'd actually like to look at both the text and the history of the text of Article 4, Section 1C. The text of Article 4, Section 1C requires the governor, when submitting an opinion to this court, that it involve something that directly impact his executive powers and duties. And here's why. The history of the amendment, the history of that specific section of the Constitution has existed since 1885. Before 1885, the governor's authority to to request an advisory opinion of this court had its genesis in 1868, in the 1868 Constitution. And Article 5, Section 16 of the 1868 Constitution permitted the governor to seek an advisory opinion from this court regarding any question of law.
But I'm sorry to interrupt you because your time's getting so short, but I mean, this is very much intertwined with the governor's clemency power. I mean, this defines the category of people when their disqualification ends, what procedures they may want to set up for people who want to apply. Maybe, they have unpaid obligations, but they want to, they've finished their probation, parole, whatever, they want to apply for clemency. I mean, it seems to me that that's a much more direct effect on the governor's executive authority than just his supervising elections, and I don't see how you could say that that's not encompassed within what the Constitution allows him to ask about.
Because this court has already answered the question, Your Honor, in regarding opinion of Supreme Court 22 Southern 681 Florida 1897, upon its consideration of the new text that's remained in the Constitution to the present day, the governor requested an advisory opinion from this court regarding his specific powers that arose as a member of the Pardon Board. That would have been under Article 4, Section 12 of the 1885 Constitution. And he wanted to know, Your Honor, whether a pardon granted by the remainder of the Pardon Board, but from which he dissented, would still be effective. And this court said, no, it's inappropriate for us to answer that question. And it did so for one specific reason, because it involved the life and liberty interest of one individual who is not a party to that case. And if this court rejects must leave unanswered a question that involves the life and liberty interest of one individual, it must leave unanswered a question that involves the life and liberty interest of hundreds of thousands of returning citizens throughout the state.
All right, if you could wind it up in a few seconds here.
Thank you, Your Honor. Your Honor, we ask this court to dismiss the governor's request as improper because it significantly expands his authority to request an advisory opinion from this court, and indeed something that Florida rejected when it adopted the language that's existed in the text since 1885. And we would ask this court, if it were to actually engage in an assessment of Amendment 4, that it conclude that it does not require repayment of all legal financial obligations, because doing so would mean every person unable to pay is serving a life sentence. It cannot be that more than 4 out of 5 returning citizens is serving a life sentence. And adopting the governor's interpretation leads to an absurd result that contravenes the chief purpose of the amendment ratified by the voters. Thank you, Your Honors.
Mr. Chief Justice, and may it please the Court, Molly Danahy on behalf of the Razor Parties. For nearly a century, this Court has repeatedly found that the constitutional avoidance doctrine compels it to adopt plausible interpretations of state law to avoid constitutional infirmity.
Have we ever applied it in an advisory opinion?
I don't know, Your Honor. I don't know the answer to that question.
I think the answer is probably no, right?
It may be.
Okay. If the answer is no, then isn't there a good reason for us not to do it in the context of where there's not a true case or controversy, in a case, as your colleague so well stated, is not even binding on us?
Well, Your Honor, I think in that case, then the correct response would be to not issue an advisory opinion and decline jurisdiction. To issue an advisory opinion where there would be serious constitutional questions at issue seems to me to not be a particularly useful...
Why? In other words, all that's been asked of us is what our Constitution means. The implications of that are for cases and controversies, including those that may exist in a courthouse down the street from here. But how does that affect what we do and what we've been asked to do, which is simply answer a question about what a term means?
Well, I think, Your Honor, that if this Court were to find that Amendment 4 requires payment of LFOs, it would put the Florida Constitution directly in conflict with the United States Constitution, as found by the District Court just this past month, which found that the the interpretation offered by the governor, the secretary, and the legislature directly violates the 14th Amendment to the Constitution.
Didn't the 11th Circuit find otherwise earlier?
No, Your Honor.
In a footnote, it found that it only was a violation if there was an inability to pay.
Correct, Your Honor, and that's what's at issue here today, is that the 11th Circuit en banc and the District Court last month found that requiring payment of legal financial obligations as a condition of rights restoration violates the 14th Amendment when there is no process or no consideration of the defendant's inability to pay.
Didn't quite say that as regard to restitution, though, did it?
It did, Your Honor. The inability to pay finding reached all forms of legal financial obligations.
What about that last sentence of the footnote?
In Johnson v. Governor?
Yeah, that's what we're talking about, isn't it?
Well, Johnson v. Governor found that conditioning rights restoration on inability to pay is a violation of the 14th.
For restitution. Does it apply to restitution?
I believe that it does. I'll have to look at...
Didn't the last sentence of the footnote say, we express no opinion with regard to restitution? Something like that. I'll get you the exact language, but...
The 11th Circuit may have left that open, but whether it's an open question or not, there's still grave doubts as to whether the...
Well, let me ask you a question, though. How is it possible, though, and I think Justice Muniz asked a question I'm not sure really got answered, so maybe I'll ask you.
Mm-hmm.
How do we deal with the fact that the parties here have specifically said at some point that all terms of sentence also includes parole, fines, restitution? How do we deal with that?
Well, Your Honor, neither the parties here nor the proponents nor the proponent's lawyer in the colloquy before this court in March 2017 are the voters, and they can't be, what their statements can't be impugned to the voters. And when you have an issue...
But how do you deal with the fact that the voters were told by people who were here, who argued before this court, who are now present, that that's what is included by the terms of their sentence includes probation, parole, fines, restitution, any other debts?
Well, two things, Your Honor. I think there were...
I mean, you don't disagree, or do you disagree that that was what was told to the voters?
Well, I do. To take a step back, I think that the voters saw many things interpreting what Amendment 4 before they voted, and some of those editorials included restitution and fines and fees. Some said that citizens would gain their right to vote upon termination of probation and parole. But what was before them in the ballot box was the text of the amendment.
Well, the Florida Rights Restoration Coalition was a party to the action before this court in 2017, correct?
Correct.
Right. And Suzanne Manning of that organization said, Amendment 4 is going to affect people who have been waiting forever, people who have done their time, people who have finished their sentence, done their probation, paid their court costs, paid their fines, paid their restitution.
Your Honor.
And that was in an editorial.
Those editorials may be relevant in the context, well, they are only relevant in the context where the text itself is not plain and is ambiguous. And where you have an ambiguous provision, this court has repeatedly held that so long as there are grave constitutional doubts, it should construe the state law in a way that avoids any constitutional infirmity.
Didn't the Supreme Court say in Martinez that constitutional avoidance is only appropriate where there's ambiguity? In other words, where there's two natural readings. If
Correct.
we don't find that there's another natural reading, if we find that the only natural reading is the one that's been articulated by Justice Lagoa after looking at everything, then how could we apply a constitutional avoidance, even assuming it applies in the advisory opinion context?
Well, Your Honor, as long as you're looking beyond the text of the amendment, then you're assuming that the text of the amendment is itself ambiguous. And as long as the interpretation that we have provided is reasonable and that the amendment is reasonably susceptible to that interpretation, again, this court's precedent compels you to avoid the constitutional problem that arises out of the requirement to pay LFOs as a condition of rights restoration and to adopt an interpretation that avoids that.
I'm sorry to interrupt you, but just when you keep talking about the requirement, do you agree that this didn't change the underlying clemency process, that anyone could still apply for clemency regardless? What I understand this to have done is that it changed the disqualification for people who hadn't committed murders or the sex offenses and who have completed all the terms of their sentence. But it didn't do anything to change the underlying availability of clemency. So there's nothing that this did that changed the status quo in that sense. Do you agree with that?
Well, I think the amendment did two things. One, it says that the disqualification arising out of a felony conviction shall terminate upon completion of sentence. And I think that is where the automatic nature of the rights restoration process comes from, is that language that says it shall terminate.
But the availability of, you still can get your rights restored even while you're still disqualified, right? I mean, that's the whole point, is while you're subject to a disqualification, you can still go through clemency.
Well,
so I don't understand if there was nothing unconstitutional about that, then how can shortening the disqualification for people who have completed all the terms of their sentence, how can that create a constitutional problem?
Well, Your Honor, one thing is that the executive clemency process is discretionary, so it is not a guarantee. Your rights, there's no imperative on the governor to grant or the cabinet to grant rights restoration.
But if that's a problem, then that was a problem before this amendment.
Correct, but what you'd be doing here is, based on an inability to pay, you would be creating two separate tracks where someone who has the means to pay off their fines and fees would have their rights automatically terminated, and someone who does not have the means is subject to a discretionary process. And I think that goes beyond what is permissible under the 14th Amendment. And again, this court—
Well, how is it a discretionary process? I mean, if it's an obligation that you have under a sentence that's been imposed by a trial court judge.
Your Honor, I apologize. I was referring to the executive clemency process as discretionary.
So are you saying that the 14th Amendment would preclude, let's take the fees and costs out. I mean, is the logic of what you're saying that if this thing had explicitly said, you know, your disqualification ends when you've completed any term of, you know, confinement and when you've paid off your restitution, are you saying that that would be unconstitutional?
It would be unconstitutional if it did not take into account the defendant's inability to pay that restitution.
Through a way other than through the underlying availability of clemency, where you could still, that could still be a reason for you to go in front of the clemency board and say, I understand I'm still subject to the disqualification, but I asked for clemency because I can't afford to pay restitution.
Correct, and the issue there is, one, currently if you have outstanding restitution, you do not qualify for the clemency process under the current rules for executive clemency, and two, the process itself is discretionary, so the governor and the cabinet, for any reason, could deny that application, and so you're subjecting someone with an inability.
So the 14th Amendment requires an all or nothing. So the 14th Amendment would allow a permanent disqualification of felons, but the state doesn't have the constitutional option to say we're going to end the disqualification when you've finished your term of incarceration and paid restitution. I mean, does that make any sense?
Well, Your Honor, it does, and the Supreme Court in Richardson held that felony disenfranchisement was constitutional, but it remanded to the lower court the question of whether the felony disenfranchisement provision at issue in California in that case was where there was disparate treatment in the application of that process. And so there is a line of cases that clearly state that even if you can take the right to vote away from someone who's been convicted of felony, you cannot restore that right in a way that violates the other limitations imposed by the Constitution.
Wouldn't those be as-applied arguments? I mean, really, all your arguments here, it seems, have to do with as-applied arguments. We're talking about a facial application of what's included in the actual text of the Constitution and what's included in there, right?
Well, Your Honor, the inability to pay is an as-applied issue, but the poll tax issue is, under the 24th Amendment, is a facial question, and the federal court in Jones raised serious doubts about whether at least some LFOs can be, are functionally a tax for the purposes
I'm quite confident Judge Hinkle can sort out what's constitutional and what's not in his court, but we've been asked as the Florida Supreme Court to determine as a matter of Florida constitutional law what's included in these terms, not to address whether it's unconstitutional or not. And even if parts of it were to be unconstitutional, then a lot of things flow from that, whether it's certain things are severable, which would be a matter of state law, not federal law, and whether the whole thing goes or whether pieces of it stay. All those things would yet to be sorted out down the road, but it's not before us right now.
Correct, Your Honor. What's before you right now is what the amendment means and what interpretation this court should adopt.
Well, can I ask you then, but so the parties are the ACLU, Latino Justice, League of Women Voters, you know, in December of 2018, when they wrote to the Secretary of State, they specifically said, we urge the department to take this view regarding eligibility of individuals registered to vote. And it said that completion of all terms of sentence included financial obligations imposed as part of an individual sentence. How can now you take an opposite view when you told another party, that the Secretary of State, who is charged with implementing and enabling individuals to have their rights restored, one thing, and now you're telling this court that that's not correct, that now it's unconstitutional?
Well, Your Honor, I think my colleague from the ACLU has explained what their position was when they made that statement, but my clients are not signatories to that letter, and neither were the voters of Florida. And what's at issue here is whether there is a reasonable interpretation of the phrase completion of all terms of sentence that excludes legal financial obligations. And if there is, this court is obligated to adopt that interpretation.
Do you agree that that letter does say that, in fact, financial obligations are part of terms of sentence?
To the extent that they are conditions of probation and parole, which I believe is the position of the ACLU. But again,
I mean, that's not what the letter said.
That's not what it says.
I mean, the letter explicitly, it said or conditions of probation and parole, and before that it said fines imposed as part of the sentence. So,
well, I do think that.
Well, counsel, what are we to take from the fact that the governor has not asked us to affirm completion? So your point is, this will all come up at the completion of the term, and if completion still has these financial obligations and they're still required to pay, then that could create constitutional problems. If we're not asked to answer what completion means, and some other court maybe is asked to answer that, and all we're asked to answer is what terms of sentence mean, which is what I hear the governor's counsel asking us to do, and we do that to be consistent with the letter of the ACLU and the op-eds and our textual reading and everything else, and leave for there, how do we steer into the constitutional problem that you're talking about?
Well, 2 points. I would quibble a little bit with the governor's statement that he's not asking you to interpret the phrase as a whole.
Did his counsel just state that right here?
He did, but the request for an advisory opinion asks you to explain whether legal financial obligations are included in the phrase completion of all terms.
I understand that, but right here I heard what I heard. Do you hear what you heard too?
If that's the position they're taking now, then not.
Do you agree that that avoids? I understand that you say that's fine. Do you agree that avoids the constitutional issue you were talking about?
No, Your Honor.
Why?
I think that it doesn't avoid the constitutional issue because you still have to define what constitutes all terms of sentence. And
agreed. That's we would define it to include whatever it is. Let's say restitution, because that's clear that's not a poll tax. Even the 11th hasn't ruled on that, and even Judge Hinkle seemed to suggest it probably is not. Well, so let's say we say it includes restitution.
There may be a question about whether restitution is a poll tax. I agree the 11th Circuit left that open in Governor Johnson v. Governor, but I do want to reiterate that the inability to pay is a different analysis than the poll tax analysis.
I agree with you. I understand. But
so
if
restitution, if you're, apologies.
Counsel, if we don't define completion, and that's left open, all we do is say what the terms of sentence means, then do we steer into the constitutional issue that you've been telling us to avoid? It seems to me that we don't.
Well, Your Honor, I think so long as our position is that so long as a condition, so long as the completion of sentence requires payment of legal financial obligations, that would violate the 14th Amendment and likely
that doesn't really answer my question.
I understand. And I would point you to, there are other instances in Florida state law defining completion of sentence for the express purpose of rights restoration under the executive rules of clemency that define completion of all sentences separately from legal financial obligations. And they define completion of sentence to include a period of incarceration and any period of supervision, and then separately look to whether a person has outstanding legal financial obligations. And that exists in the clemency rules, even for people who are applying for remission of their fines and fees. And so I think to the extent that you're adopting a definition of terms of sentence that is consistent with Florida law in the context of rights restoration, it's incumbent upon the court to look also at the Florida state law that exists that's on point in that context.
But there are a number of statutes that say exactly the opposite of that, right?
Well, I think there's been some dispute here today and in the briefing among the parties about whether such things as parole or probation are sentences.
Well, counsel for the House cited a statute which specifically called a specific kind of fee, I think it was a public defender fee, part of the sentence, right?
I believe that's the case, yeah.
Okay, so why wouldn't that be part of the sentence if Florida law defines it that way?
Well, it's not defined that way in the context of rights restitution under the rules of executive clemency, and there's no reason why this court couldn't adopt the same definition here.
Let me ask you this. Criminal defendants who are acquitted, are they subject to cost and fees, the imposition of cost and fees?
I believe there are costs and fees that are imposed on criminal defendants for which they are responsible, even if they are not adjudicated guilty. And I know that's the case for defendants who have adjudication withheld, who under Florida law would not
the question was with respect to
vote,
acquitted defendants. There are no costs or fees or anything that are imposed on them, correct?
Your Honor, I know that all of you are more familiar with Florida criminal law than I am, so I would defer to your...
Doesn't the public defender fee apply even if for acquitted conduct? In other words, doesn't the public defender, if you hire the public defender, you're required to pay, I think it's $50.
I believe that's correct, and I know that it's correct in the case of where a person their adjudication is withheld and they're not convicted.
Yeah, but that's not the acquitted example.
It's not acquitted, but it would still be a case where you would not lose your right to vote because you would not be convicted of a felony, but you would still be on the hook for a fee that is taxed to you by the state. I have nothing further if there's no further questions.
Thank you.
Thank you.
May it please the court. The question posed by the governor should be answered on the plain language of this phrase, all terms of sentence, including parole or probation. 3 quick points. All terms of sentence is everything in a judge's sentencing order. There's no basis to parse punitive versus non-punitive or the purposes of punishment versus deterrence. It's all penal.
Your colleague, though, suggests that we should look at the statutes governing. Should we look at the statutes, or should, even if something is not authorized by statute but is contained within the 4 corners, that is the sentence?
This court can make this determination based on Amendment 4's language. The statutes show instances in which costs and fees and restitution are part of a sentence, but there's no need to go to the statutes to define this phrase. It can be done by its plain language. Second, the phrase including parole and probation can't be the tail wagging the dog. The including phrase doesn't foreclose LFOs, but ensures parole and probation are to be completed. And third, whatever civil enforcement may be necessary to collect LFOs, everything a judge puts in a sentence, a felon must repay in terms of debts to society to regain voting rights.
I get to the completion point, though? I mean...
So, to be clear, the governor isn't requesting this court answer a question of completion.
So repaying debts, I mean, that doesn't... I mean, the question is, what is the sentence? What are the elements of the sentence? And then as far as whether you've completed that or whether you've repaid debts or whatever, I mean, that seems to me to go more to completion and to kind of the end point.
The question the governor's asking is, are all those debts to society included in all terms of a sentence? And he would ask this court find in the affirmative. If there are no further questions, then I'll conclude our argument. Thank you.
All right, we thank you all for your arguments.